There's several examples of a slip and fall accident that are common when you see a slip and fall. One is like in an apartment complex, maybe falling down the stairs, maybe in a parking lot. If you're in a parking lot, it can be ice and snow, or maybe it's in a grocery store and there's like water, or there's maybe food that's left in the aisle, and you slip, you fall, you hurt yourself. Those are very common things that you find in slip and falls. Well, negligence is a different idea. For negligence, you got to prove a few things. Negligence has to do with duty, the breach of that duty. It has to do with causation for the accident. And then you also have to prove that there was no warning and that the owner knew about the defect. And so proving negligence then is proving all of those things, that the property had a defect, that the property caused your accident, that there wasn't a warning that you could see, and that the owner should have known about the defect. So if you're looking for examples of a slip and fall, essentially one I think that everyone in Michigan can relate to is a parking lot. And if it's been snowing all week and the owners don't ice it, they don't shovel it, and you have to walk through a thick thing of ice and snow to get to the door, you slip, you fall, that would be an owner being negligent. And the same thing would be like an apartment complex where you walk down your stairs to get to the door and the hand railing is loose and it just falls. And someone's complained before and they just never did anything. That would be an example of negligence. Proving negligence is sometimes difficult and sometimes it's not. I mean, when you're looking at a negligent situation, you have to look at what is the available evidence to prove all of these things. Sometimes it can be someone who saw the accident. Sometimes it can be a video, which is kind of the best proof that you have. But you also have to think about how to prove that the owner knew about the defect. Because simply if you watch someone on a video, they fall, that doesn't mean that the owner should have known about the thing that was wrong. So you have to also prove that. And so there are a few things that you might need a lawyer, an investigator, or someone with some experience to help you prove. A duty of care is essentially a legal standard for when someone is responsible to not do something wrong. And a property owner has a duty of care to make sure there are no unreasonable risks of danger on their property. And so what a duty of care in premise liability or slip and falls is basically means they have a duty, or they are supposed to make sure that their property is safe. That's their duty of care. Right. So sometimes you think that maybe a slip and fall is straightforward, that I fell on their property, I hurt myself, why can't I just negotiate with the property owner themselves? The problem is, one, it's the insurance company, not the property owner that you're dealing with. Another problem that you're going to have is that trying to get the best evidence is not necessarily easy, nor do most people know what kind of evidence they really need. So whether this is medical evidence of your injury, whether this is knowledge of the property owner's acknowledgement of the defect on the property, there's a lot of different pieces that have to be put together in order to prove negligence. And even if you think it's straightforward, it probably isn't, and the insurance company is going to try to put some roadblocks in your way to make sure that you don't get the best recovery. So you really need to be able to cover your bases. So when you're looking at slip and falls, think about what a slip and fall is if you're thinking about common injuries. You're basically standing 5 or 6 feet tall and you fall over or even down something. And a lot of times this can hurt almost every single part of your body. You can hurt your leg, you can hurt your arms, you can even hurt your neck or your back. I mean, realistically, you're looking at sprains, broken bones, maybe herniated discs. These types of things are very common with slip and falls. In order to sue someone, you could technically sue someone for any type of injury. The question is whether it's worth the cost and expense of bringing a lawsuit. And so what you really want to make sure is that you have a serious injury that's actually going to change the way that you have to live your life for a substantial period of time. So if you have bruises, bruises are going to get better in a couple weeks. But if you have a broken leg or a torn ligament, it's going to take weeks, it's going to take months, it's going to be painful, it's going to disrupt your life. Those are the types of injuries that are viable lawsuits. Well, compensation comes from an insurance company through a slip and fall almost all the time. So the property owner has an insurance policy, just like you have with your car or with your home. You make a claim just like you would if something happened in your car or your home. Now, the insurance company usually wants to see some things before they're ready to give you compensation. They want to see that there's actually negligence, and they also want to see that you're actually hurt, and they want to know how bad you're hurt. And so it's an attorney's job to help you prove those things and show it to the insurance company. Because if you just show up and you say, I was hurt, it's not going to be enough to get the insurance company to get you compensation. So when you're talking about an injury and damages, damages are the things you're going to be compensated for. And these types of damages are basically threefold. You're looking at lost wages if you can't work anymore because of the injury. You're also looking at pain and suffering. So you have pain and suffering as a result of essentially a painful situation that disrupts your life. You also have medical bills. So like if you have to get treatment or surgeries, all of these things have to either be paid directly or reimbursed to your other insurance company who paid those. So Michigan for the last couple years has been really a kind of bad place to file a slip and fall lawsuit. There were lots of defenses. The main one was open and obvious. If a defect was being able to be seen on the property and you hurt yourself as a result, you can't bring a lawsuit. Michigan had a different law before 20 years ago, which they just recently reverted to. And so now this is the type of negligence that you would usually see, meaning duty, a breach of that duty, a causation, and then an injury. And if you can prove those things now in Michigan, you can have a viable lawsuit. And so everybody who's hurt in Michigan on a slip and fall is going to benefit from this rule because it's much easier now to bring a lawsuit. Determining how much a case is worth is kind of an art rather than a science. No one's going to be able to put into a calculator exactly how you hurt yourself and what exact the injury is and how much you're going to get paid. Impossible to do. Every situation is different. And so you have different medical bills, you have different injuries, you have different types of pain, suffering. Maybe you had a job and you lost some wage, maybe you didn't. And really the only way to tell how much your case is worth is to talk to someone experienced in personal injury and in slip and falls, and they can basically discover the types of things that went wrong or the things that are bad that happen and make a good recommendation or a good guess about how much your case is worth. So the statute of a slip and fall case, the statute of limitations, is 3 years from the date of the slip and fall. So that means you have up to 3 years to file a lawsuit, not a claim. You can't just contact the insurance company within 3 years and think you're fine. You actually have to file a lawsuit within 3 years. And so if you've waited 2 years or 2.5 years and you're looking for a lawyer now, you're going to be in maybe some trouble because a lot of lawyers are going to look at that and say, hey, look, I don't know if I have enough time to investigate this thing and figure out whether we can help you. And so you want to bring that lawsuit or that potential lawsuit to an attorney as fast as you can so that way you don't miss out on compensation that you would deserve. So a lot of people are concerned when they first talk to a lawyer, or they're even thinking, should I bring a lawsuit or not? I mean, they probably didn't try to hurt you. It wasn't like someone took a bat and broke your leg. You slipped on something, you hurt yourself. Is it right to sue? Well, I mean, is it right to collect damage to your car when you hit something, for insurance? I mean, insurance is there for a reason, and there really isn't anything wrong with making a claim. Now, the process isn't going to be that onerous on a person. However, you do have to do a couple things. You do have to make sure that you contact a lawyer and that you help them facilitate getting the evidence that's there. So whether that's your medical bills, whether that's, a statement that you might have made to the store or the owner of the property. And the process itself is basically getting treated, talking to a lawyer, building the case, and then either a settlement or litigation after that. And litigation is simply a fancy word for saying we don't agree, we want the court to help us decide. It can take a matter of months. It can take a little bit longer if you're in litigation. Usually, if you're not in litigation, it's not going to take that long, but you do want to know what your injuries are and how bad they are before a claim is finished. Well, the property owner isn't the one who's making the decision is the problem. So if you know the person whose property you got hurt on, it's not a matter of asking them, hey, can you settle the case? They're not going to be able to do that. You got to deal with the insurance company, and the insurance company has lawyers, and the insurance company has a CEO, and they have all these things that you have to go through in order to get a settlement. So it's not as easy as just talking to your buddy and getting it done. You have to go through the proper channels. So trespassing is a little bit different. If you weren't supposed to be on the property and you hurt yourself, common sense would say, well, maybe you shouldn't be compensated for that. However, there are certain rules that might allow you to get compensation. So even if you weren't supposed to be there, if you can prove that the negligence was really high on the owner of the property, you might still be able to get a recovery. If an insurance company contacts you, I would be wary of that. A lot of times an insurance company isn't going to give you the best settlement or the best offer right off the bat. They're going to try to minimize your damages so they don't have to pay very much. Insurance companies are a business, and their business is to take premiums and not pay out. And so I wouldn't trust an insurance company, whether it was a release or whether it was a settlement offer. I would find a lawyer to help you out because you need some help against these guys.